So, guys, welcome back. Tension continues to rise as Omotosho is said to be facing one of the difficult moments of his career, following reports that the International Criminal Court (ICC) has moved to examine alleged unlawful acts linked to the ongoing Nnamdi Kanu case. What was once handled quietly is now attracting serious international attention. Omotosho charged Nnamdi Kanu on a dead ground, on a dead law, and now international law are coming to involve in his case. Stay tuned as events continues to unfold.
If a defendant is raising an objection, you don't say because you want to deliver judgment, you want to end the case, you go ahead and deliver judgment. When in section 36 of the 1999 Constitution, it says that the defendant must be given adequate time and facility to prepare for his defense. There are times when
he was given more than enough opportunity.
No.
Especially when he said he wanted to defend himself. The judge kept telling him
when he filed the objection, the motion to challenge jurisdiction, the judge refused to hear the motion. Objection can be brought at any point before judgment.
Wow.
No, is it because lawyers just kept quiet? You can't. This is the first judgment that we are putting something on nothing and expecting it to stand. It cannot stand. This has nothing to do with emotions. And the fact that a defendant is unruly in court, uncultured and mannerless, does not give the court, does not empower the court to pass judgment against him. The court will charge him for contempt or any other remedy available to the court. So because I've heard people say because he was unruly, that is why the court had to quickly, that is judicial blasphemy. To convict a man because he's unruly. No.
See, it's actually interesting, Barrister, you're saying. Yes, Barrister, sorry to cut in here. It's actually very interesting as you fleshing out some of these things and expose them as much as you can. But as a lawyer, is it fair to say that at this point you are questioning the intellectual dexterity of Omotosho SAN at this point, and knowing what he had going on?
Very well. What do we do on appeal? I can talk like this now because the case has ended. And they have not filed appeal. They are filing today or tomorrow. The reason lawyers cannot talk outlandishly before night because the matter is sub judice. When a court lacks jurisdiction, it lacks everything. There is an absolute miscarriage of justice in that case. Nothing comes from nothing. You cannot pull something from nothing. Nothing is equal to nothing. The judgment itself did not follow the basic legal principle for which we ought to have followed. When you look at the spread of the case, there are three fundamental issues. First, the law upon which he was charged had been repealed. Okay, so the statutory absence of the existence of that law itself, foils that issue. Okay, two, the objection raised by Nnamdi Kanu in terms of the objection that relates to that the court lacks jurisdiction to that effect was not adhered to by the judge. Present objection under the law. Once it is brought, the law says that it can be raised at any point before judgment. So, and once it is raised, the court must first of all suspend whatsoever it is doing to attend to that. When the issue of jurisdiction is raised, the court must first of all assume jurisdiction to determine whether it has jurisdiction or not. That was not done. The third one has to do with proof beyond reasonable doubt, the material evidence, the nexus, that the unequivocal evidence that's supposed to link Nnamdi Kanu to the charge was not there. Like the lawyer said, there was no weapon. Even when you go beyond that, there was nothing direct. You are saying he made this statement, he made that statement. All those whom were affected, nobody was called as witness to testify. So the court solely relied on circumstantial evidence under the Evidence Act. Circumstantial evidence requires corroboration before it can be fit for conviction. So when you look at the case in its totality, this three defects deflates the argument put forward by that judgment for the conviction of Nnamdi Kanu.
A very big win for Mazen Nnamdi Kanu. Another learned lawyer raises serious alarm over miscarriage of justice. Before we continue watching this very interview, let's understand the basis of what the lawyer is talking about. He describes the conviction of Mazi Nnamdi Kanu as nothing short of a total miscarriage of justice. You all remember in our previous video, a constitutional lawyer broke down the judgment and exposed what he called deep legal contradictions and judicial errors. Now, another legal expert has stepped into the spotlight, reinforcing those concerns with fresh legal arguments that shake the foundation of the entire conviction. According to this very lawyer, there are three fundamental legal principles upon which the judgment rests. According to this lawyer, he says that three fundamental legal principles upon which the judgment were actually, carried out are fatally defective. What does that mean? It means it doesn't have any stance. First, he states that the law under which Nnamdi Kanu was charged had already been repealed. Just like what I told you, Nnamdi Kanu, insisted that the law through which he's been charged, he's been tried, is a repealed law, making the prosecution legally questionable from the very beginning. Secondly, the lawyer also alleged that the court failed to properly address Kanu's critical objection on the question of a jurisdiction, a preliminary issue that must be resolved before a court can lawfully continue any trial. And lastly, the lawyer also argues that the key material evidence allegedly linking Kanu to the charges, including the so-called evidences that is presented to the court by the prosecution, was never properly established in the court. As a result of this very legal principle that is being deflated, he insists that there was no credible proof that the accused, being Nnamdi Kanu, committed the offense as alleged. And under Nigerian law, the prosecution must prove its case beyond reasonable doubts, not by suspicion, not by theory, but by solid and reliable evidence. It means the prosecution must prove guilt so clearly that no reasonable person can doubt the truth based on the evidence presented. And I ask, Omotosho, where is the evidence that was presented before you by the prosecution? Help me in the comment section. Ask Injustice Omotosho, where is the evidence that was presented to him by the prosecution that made him to jail Mazi Nnamdi Kanu? According to this lawyer, the court relied heavily on a circumstantial evidence, which under the Evidence Act requires strong corroboration before it can sustain a conviction. In the words of this very lawyer, these three defects alone are sufficient to collapse the substance of the judgment. Ladies and gentlemen, let's now continue watching the interview as this lawyer lays it all bare and clear.
In criminal cases, the law says that you cannot charge someone for an offense not known to law, and you cannot charge someone for an offense that is not in a written law. So if you are charging someone on a law that has been repealed, and you have that in your charge sheet, what you need to do is to first of all address that as a prosecution counsel or the prosecution team, which was not done. Okay, criminal trial requires proof beyond reasonable doubt. It is not enough to say he made statements. To whom did he make the statement? Where are the witnesses? Where are the evidence? Okay, upon his conviction, on what basis are you arriving at his guilt and thereafter his conviction and sentencing? Okay, so we don't, in law, you cannot, apply speed and kill it on the altar of technicality. So the court, I absolutely agree with the lawyer that that judgment is sitting on a very wrong tripod, because by the time you clear those three angles, three aforementioned angles, there's nothing left of that judgment. Because it is political, perhaps there is a pressure to score points, but the law does not see it that way. Whether a matter is political or not, even if a matter is political, it must conform to legal process, legal proceedings. If a defendant is raising an objection, you don't say because you want to deliver judgment, you want to end the case, you go ahead and deliver judgment. When in section 36 of the 1999 Constitution, it says that the defendant must be given adequate time and facility to prepare for his defense. There are times when a judge
Barrister, he was given more than
judgment.
enough opportunity.
No.
Especially when he said he wanted to defend himself. The judge kept telling him
when he filed the objection, the motion to challenge jurisdiction, the judge refused to hear the motion. He was given enough time to enter his defense, but he opted for a motion.
So what's the difference?
To challenge the jurisdiction. Yeah, there's a difference.
Yeah.
Okay.
You are asking him to open his defense. That's to call his witnesses that he has listed. He listed many of them. You're asking to call them and have his case dispensed with. You understand? You gave him enough adjournment on that. In the process of that, he came up with a motion. He brought out a motion. He filed a motion and said that I am challenging the jurisdiction of this court. It's allowed in law. Objection can be brought at any point before judgment.
Wow.
Yes. There are times when the judge has written a full judgment, has adjourned to deliver the judgment, and will file motion to arrest the judgment. It's allowed in law. So what will now happen is that instead of the court to go ahead to deliver that judgment, the court will suspend that judgment, the substantive suit, and focus on the motion filed. Okay? And then deal with that motion to its conclusion before it goes back to the judgment. That is the law. Okay? So if that was not followed, would you still say that the judgment is sound?
So guys, Justice Omotosho's name has surfaced repeatedly in this discussion due to his role in high-profile political sensitive rulings, placing him at the center of a wider debate about judicial independence, accountabilities, and international oversight. So guys, I want you guys to stay tuned. Hit the subscribe buttons for more trending videos.